So the new process is an arbitration process. It's been set out within this new legislation in order to help landlords and tenants decide how much of the tenant's arrears should have to be payable. And we would always, in the first instance, advise our clients to try and come to a deal directly with their landlord, their tenant. But we appreciate sometimes that's simply not possible, no matter how hard you try. And so this new regime is there to assist landlords and tenants in deciding what to do about these arrears. In March 2020, the government put in place a number of measures to protect businesses, in particular the high street. And one of those measures was putting in place a moratorium on commercial forfeiture, especially for commercial rent arrears. So as a result, since March 2020, initially for just 3 months, commercial landlords have been unable to re-enter or forfeit their tenants' commercial premises and forfeit the lease for rent arrears. That was initially supposed to be for 3 months, but of course the pandemic's gone on a lot longer than anticipated, and after a series of extensions, it's now finally come to an end recently on the 25th of March this year, having been in place for just over 2 years. Parliament has just recently passed the Commercial Rent Coronavirus Act 2022, which puts in place a scheme of rules designed to assist landlords and tenants dealing with whatever rent arrears may have accrued over the last couple of years during that moratorium that's been in place since March 2020. And the aim of that regime is to avoid the cliff edge that would otherwise be fast approaching with the end of the moratorium, given that we've had 2 years during which tenants could have been accruing all of these arrears that landlords have been unable to deal with until now. And the government recognises that landlords have been unable to do anything about rent arrears for an awfully long time now, and that actually the moratorium has needed to come to an end. But the government also recognises that actually there may well be tenants with up to 2 years of rent arrears that have accrued, and in cases where those rent arrears have accrued because of the restrictions that have been put in place by the government because of the pandemic, there needs to be some assistance from the government, by way of legislation, to ensure that that doesn't become the nail in the coffin for the tenant's business. So in the first instance, the landlord or the tenant will serve the other with a notice saying that they want to make a referral to the arbitrator, and that notice will include their proposals for how this rent arrears should be dealt with. The other party can accept those proposals, but also they can respond within 28 days with proposals of their own. And if at the end of that process the parties have reached an agreement, it can then be referred to one of the government's appointed arbitrators. The arbitrator will then deal with it by way of a 3-stage process. So stage number 1 is all about the viability of the tenant's business. If the tenant has a viable business, and it's viable even without a penny's rent reduction, then the arbitrator will strike the reference out. Likewise, if the tenant's business just simply isn't viable, even if there was a complete waiver of all of the rent arrears that had accrued, again, the referral will just immediately be struck out. If the parties get past that first stage to the second stage, then the arbitrator is going to deal with the 2 proposals by the landlord and tenant in accordance with the arbitrator's principles. And those principles are to preserve or to restore and preserve the viability of the tenant's business, so far as it is consistent with the landlord's solvency. And I think that's a really important thing for landlords to understand, is that this isn't just about keeping the tenant in business. Actually, if keeping the tenant in business is going to come at the expense of the liquidity, the solvency of the landlord, then actually the arbitrator just simply won't do it. And so what the arbitrator will do is take a look at the two proposals from the landlord and the tenant, and they will decide to what extent are those proposals consistent with those arbitrator's principles. If they're both consistent with the principles, then the arbitrator will pick which of those principles is more consistent. If only one of them is consistent, then the arbitrator must make an award in line with that consistent proposal. And if neither of them are consistent with the arbitrator's principles, then it will move to the third stage of that three-stage test. And the third stage of that three-stage test is the arbitrator's discretion. So the arbitrator will be able to look at the parties, look at their proposals, look at the evidence that's been put before him, and make a decision based on his own discretion as to what the tenant should pay in respect of those rent arrears. Crucially, these changes apply to what the government is calling protected rent arrears. And protected rent arrears are arrears that have accrued during the protected period. The protected period is going to be different on a case-by-case basis. It's always going to start 21st of March 2020, but the protected period then continues for whatever period the government had in place pandemic-related restrictions for that tenant's particular industry sector. So at the latest, that's going to be 19th of July 2021, but the protected period may well end for some tenants earlier than 19th of July 2021. And any arrears accrued during that protected period are what the government is calling protected rent arrears. Any unprotected rent arrears aren't subject to these rules, and landlords are entitled to carry on in the pre-pandemic way, pre-moratorium way, immediately without having to know anything about it in respect of unprotected arrears. Yes, one thing that's really important for landlords to know, especially if they believe that they have unprotected arrears, is that any rent received during the protected period, i.e. any rent received since 21st of March 2020, must be allocated to unprotected arrears. So an awful lot of landlords may well believe that they've got unprotected arrears and that they can proceed immediately, but actually in many cases they may not, and it's important that landlords take independent legal advice before they take any action to ensure that they're not going to open themselves up to a risk of committing forfeiture.